everyone, and welcome to this discussion in which Andrew Butler KC and I are going to be considering a recent Court of Appeal decision on the topic of implied contractual obligations of good faith. And that case is Candey Limited and Bosheh, a decision handed down on the 1st of August 2022. Although there has been a substantial number of decisions on this topic in courts of first instance over the past decade, this is, perhaps somewhat surprisingly, the first time the issue has reached Court of Appeal level. So it's interesting to see the approach taken by the Court of Appeal, particularly having regard to the fact that, as we shall discuss, slightly competing approaches as to how to resolve this issue have emerged in the lower courts. Andrew, perhaps I can start by asking you to explain the context in which the issue arose in Candey.
Thank you, Sara. Yes, but probably not the context one might have expected. It actually arose in the context of a relationship between a litigation solicitor and its client. Arguments about good faith usually arise in the context of more conventional commercial relationships. Furthermore, it was actually the solicitor who was seeking to establish that the client owed it a duty of good faith, rather than, as might have been expected, the other way around.
That does sound odd. Why did it matter?
Well, the Court of Appeal described the notion that a client might owe his solicitor a duty of good faith as, quotes, a startling concept, close quotes. So they certainly seem to have thought it was odd. The reason it mattered was because the solicitor was acting for the client on a CFA. The client rejected a particular offer of settlement, which, according to the solicitor, would have constituted a success under the CFA and entitled the solicitor to an uplifted fee. Whether or not that was right, and the client disputed it, the client then arrived at a settlement which undoubtedly did not constitute a success, and which therefore not only did not entitle the solicitor to an uplifted fee, but didn't entitle the solicitor to any fee at all. It was in that context that the solicitor brought the claim, which ended up before the Court of Appeal.
So the solicitor's case was that the client's decision to settle on terms which denied the solicitor any fee constituted a breach of an implied obligation of good faith.
Exactly, yes.
And had that been the subject of a trial?
No, the client had applied to strike out the solicitor's claim, and the judge at first instance had acceded to that application. So this was the solicitor's appeal against that decision.
And was that the only issue that arose?
No, there were subsidiary issues about the extent to which the solicitor should be permitted to rely on privileged and confidential documents in pursuing its claim. These were quite complicated issues in themselves, but obviously secondary to the question of whether the claim was viable at all. So the focus of the Court of Appeal's decision was the good faith issue.
And how did it determine that?
Well, in short, it unanimously upheld the judge's decision, but the terms in which it did so were interesting.
How so?
Well, the first thing which caught my eye when reading the judgment was Lord Justice Coulson's comments on the frequency with which claims of this kind are now coming before the court. He traced the development of the law back to a case called Yam Seng and International Trade Corporation, a 2013 decision in which Mr. Justice Leggett, as he then was prepared to recognise the existence of an implied obligation of good faith in certain types of commercial contract. Lord Justice Coulson said that since this case, there had been what he described as an avalanche of similar claims. He also made the point that very few have succeeded.
So do you discern from that a certain degree of judicial weariness on these claims?
I think weariness would be too strong a word, and as I said earlier, this is actually the first case on the topic which has reached the Court of Appeal, but it may be possible to detect a degree of scepticism, at any rate, on the part of Lord Justice Coulson.
You said that was the first thing that caught your eye, and what else did you find of interest in the judgment?
Well, seasoned observers of this area will know when it comes to deciding whether a contract contains an implied obligation of good faith that two different approaches have emerged from the authorities. On the one hand, some judges have considered whether the contract before them is what they've called a relational contract, that is, in essence, a long-term collaborative arrangement. Examples of that might be joint ventures, franchise agreements, or distributorships. If the contract before them is a relational contract, then on that approach, a duty of good faith will invariably be implied.
And what is the other approach?
Well, some judges have approached the question rather differently. For example, Mr. Justice Fancourt, in a 2019 case called UTB and Sheffield United Limited, preferred to adopt the conventional approach to the implication of terms, which was reaffirmed by the Supreme Court in Marks and Spencer and BNP Paribas. In other words, implying a term only if it's necessary to do so to give business efficacy to the contract, or if it represents the obvious but unexpressed intention of the parties.
So which of these two approaches did the Court of Appeal adopt in Candey?
Well, actually both. One of the slight frustrations with the decision in Candey is that the Court of Appeal did not express a preference between the two. Lord Justice Colson, who gave the main judgment on this issue, applied the two tests in turn, but both, he said, yielded the same result, namely that the judge was right to reject the contention that there could possibly be a duty of good faith owed by the client to the solicitor.
And what was his reasoning?
Well, as regards the conventional test for the implication of terms, Lord Justice Colson said simply that the term was not so obvious that it went without saying, that a solicitor's retainer did not require any duty of good faith on the part of the client in order to make it work, and the fact that the retainer was on the basis of a CFA made no difference in that respect. He also observed that the solicitor's argument involved putting it in something of a win-win situation. The underlying case turned on the client's credibility, so that if he won the case, the solicitor would recover its success fee, but if he lost the case, the solicitor might always be able to argue that he must have known he had acted in bad faith and was therefore also acting in bad faith in entering the CFA in the first place, so that a solicitor would have had an automatic right to a claim for breach of contract in that event.
And what about the relational contract approach?
The court rejected the contention that the retainer was a relational contract. In doing so, they applied a checklist which was set out by Mr. Justice Fraser in a 2019 case called Bates and the Post Office, part of the sub-postmasters litigation. They held that the retainer did not satisfy most of those criteria, hence it was not a relational contract. A key point which was argued by the client in that context and accepted by the Court of Appeal was that the fact that there were no fees, the fact that no fees were due on the outcome which had transpired was a simple function of the wording of the CFA, which was the solicitor's responsibility. No question of a lack of integrity on the part of the client arose. The CFA simply said what it said.
That's interesting. I mean, do you think that is something which could cause practitioners to revisit the terms of their CFAs?
Yes, I think it is. Although the solicitor's appeal in Candey was dismissed, one can perhaps see why they ran the case they did. The CFA is different from a conventional retainer in that it aligns the lawyer's financial interests with the client's financial interests. So if a client hoodwinks a lawyer into entering a CFA, or as in this case, engineers an outcome which denies the lawyer their remuneration, then the lawyer will suffer loss in a way that it will not if it's instructed on a conventional retainer. That will invariably cause ill feeling and perhaps even a sense of betrayal. The lawyer may feel that it and the client were in it together and that it's been let down. But on the basis of the Court of Appeal's decision, that problem can't be guarded against by recourse to an implied obligation of good faith. It can only be guarded against by including express words in the CFA.
So there might be some practical implications there for practitioners. But returning to the substantive law, what are your thoughts on these two approaches to the implication of obligations of good faith?
Well, for what my thoughts are worth, I'm more comfortable with the approach of Mr. Justice Fancourt, what might be called the conventional approach. I think there are a few problems with the relational contract approach. First of all, it promotes a rather binary all or nothing outcome. Either a contract is a relational contract, in which case obligations of good faith will be implied, or it's not, in which case they won't be. That seems to me to be rather artificial. And I also can't see why a contract with, say, a 6-month duration might give rise to obligations of good faith when the self-same contract with a slightly shorter duration might not do so. A second consideration is that, as Mr. Justice Fancourt said in the UTB case, the relational contract approach may not pay sufficient regard to the express terms of any particular contract. And finally, there's obviously also a benefit in the courts adopting a uniform approach to the implication of a term, irrespective of the nature of the particular contract which is before them.
But might it not be possible to see these two approaches as two sides of the same coin? So, in other words, if a contract is relational, a relational contract as described by Mr. Justice Fraser and Bates, it will for that very reason satisfy the conventional tests for the implication of a term which were reaffirmed by the Supreme Court in Marks and Spencer.
I think there is something in that, yes. It may be that the checklist put forward by Mr. Justice Fraser and Bates represents nothing more than an attempt to identify when an implied obligation of good faith will be regarded as satisfying those conventional tests. It would, I think, have been helpful if the Court of Appeal in Candey had felt able to give some guidance on the relationship between the two approaches, or given an indication as to which of them it preferred. But for whatever reason, it evidently decided that that was not the case in which to do so.
Does Candey offer any assistance on the question of what an implied obligation of good faith will actually require if it is to be implied into a contract?
No, it doesn't. The court didn't go further than to say that no obligation arose on the particular facts of that case. But there are other, albeit first instance, authorities in which judges have given guidance on what the obligation involves. For example, Mr. Justice Leggett, who, as I've said, can really be regarded as a key proponent of the development of this area of the law, said in a 2017 case called Astor Management and Atalaya Mining that it was a modest requirement and less onerous than, say, a best endeavours clause. What the concept seeks to encapsulate and to prevent is conduct which would be regarded as commercially unacceptable by the standards of reasonable and honest people. Dishonest conduct will always meet that test, but conduct falling short of dishonesty may also do so. The concept can perhaps be encapsulated by a phrase like sharp practice or similar, and cases in which the obligation have been found to have been breached usually involve some pretty remarkable sets of facts.
Andrew, could you give us any examples of this?
Well, Yam Seng, to take one example, was a claim by a distributor against its supplier who had refused to supply goods for distribution, signified an intention to breach an exclusivity requirement, and given false information about pricing. A second case, D&C Cars and Essex Police Authority, involved a car dealer which was in partnership with the police, disregarding an instruction for the crushing of a vehicle recovered from a crime scene, and instead incorporated that vehicle into its fleet. What these sets of facts all have in common is that they were perhaps not the sort of things which were ever likely to be the subject of express terms in a contract, if only because they were so unforeseeable. But they are things which one would recognise straight away as running contrary to the spirit of the particular relationship or agreement.
Thanks, Andrew. I have one final question for you. How do you see this area of law developing in the future?
I doubt it'll be long before we see further claims coming before the Court of Appeal. As I've said, it's perhaps a surprise that only really one has to date. The signs are that the appellate courts remain resistant to claims based on good faith. We shouldn't forget that as recently as 2021, the Supreme Court in Times Travel and Pakistan International Airlines reiterated, albeit in a slightly different concept of economic duress, that there is no general doctrine of good faith in English law, citing the uncertainty that that might cause and its potential for undermining the express terms of a contract. The court in Candey was obviously similarly unreceptive. On the other hand, it's hard to dispute that the implied obligation of good faith has a valuable role to play in preventing commercially unacceptable behaviour, as is demonstrated by the facts of the cases I referred to earlier and other similar cases. So we're at perhaps a bit of a watershed. What can be said, I think, is that there is some distance to go before the law reaches a state of settled certainty on issues of this kind.
Thanks, Andrew. This is definitely one to watch. Thanks too for everyone for watching this webcast, which will be the first of many we at Tanfield will be producing on topics of current interest. Please look out for them and tune in again.